one of the main issues that people do still worry about under volunteers in the law as a topic, and the thing I get asked probably the most questions about when I do talks on volunteers in the law, still goes back to health and safety. Partially because volunteers have this very strange legal position in that most legislation that gets drawn up around the workplace that gives employers, organisations responsibility refers to employees, their paid workers, doesn't explicitly include volunteers. Not as difficult as it may sound, because organisations have a very clear duty of care towards volunteers. There's also some duties under the Health and Safety at Work Act to take account of health and safety of anyone who might be affected by their work. So volunteers are fairly well protected. But health and safety is quite a difficult topic because organisations get very concerned about the dangers of being sued. Volunteers being injured in some way, suing them, or the people that they work with being injured and suing the volunteer or the organisation. This does tend to stem back from things such as a few years ago, I'm sure we all remember the problems in the insurance industry where organisations were facing a premium skyrocketing. In some cases, organisations couldn't even get insurance. Also, this idea of the compensation culture. That anyone can just trip over, sue the council, get £500,000. Now, actually, compensation culture is a bit of a myth. There's a really good piece of work by Better Regulation Task Force that looked at the reality behind this idea of compensation culture. Found that court cases weren't particularly rising. Slight rise if you look over a kind of 10-15 year period, but certainly weren't skyrocketing. And courts are very, very good at throwing out spurious claims. We do see stories that make the tabloids, but that's because they're the exception. And quite often, they're also American. We've got the best stories. Favourite story was the guy who bought, I think it's the Winnebago, one of those big mobile homes. And he took it out on the freeway, set it off, riding along, put it in cruise control, got up, went back to make a cup of coffee. Not surprisingly, it veered off the road. He sued successfully, and ever since the company that makes these mobile homes put a little passage in their driver's manual to say that cruise control isn't the same as automatic pilot. So you can understand people's concerns that actually in this country, courts are fairly good at throwing out spurious claims. However, even if the reality of compensation culture isn't true, the fact there is this myth compensation culture is almost as damaging. Partially because organisations do have to be aware that some people have this idea that they can just sue at the drop of the hat. Even if it's never going to come to court, you've still got the expense and the concern of dealing with that issue. But also because organisations therefore overemphasise the risks that they actually face. There's a danger of stopping doing reasonable activities for fear of it being too dangerous. Volunteers who will get injured and sue, or the people they're working with will get injured and sue. So it is an issue there. And since the book came out, Volunteers in the Law, government has taken some of this on board and included a section within the Compensation Act 2006 to try and, in a sense, allay some of these fears. What they did, in effect, is nothing more than actually put into legislation tends to be the actual case in reality, but put into statutes, which is that when a court's looking at a person's claim for damages, and whether or not the organisation has been negligent, they can take into account whether any steps that the organisation may have taken, which could potentially have lowered the risk, would have actually ended up in stopping the desirable activity going ahead. So the idea being that there are certain activities which society sees as desirable, which does include voluntary activities, sports activities, school trips is a classic example here, out courses. The idea being that organisations do not have to take so many steps to prevent anyone from coming to any harm at all, that what they're doing is actually preventing that activity. It's the idea that you can send kids out whitewater rafting without giving them full diving suits. You know, the idea around dealing with risk and risk management is not to remove risk altogether, it's to ensure that there aren't any unacceptable levels of risk. Every activity has inherent risk. You know, me coming here today was a risky activity. You know, walking around where I live is quite risky. But you know, I accept it, I do it, and we all do that. You know, we cross roads. And that's the kind of feeling we need with our voluntary activities. It's not about removing risk altogether. It's about realising where there are unacceptable levels of risk. It doesn't mean that any time a volunteer or one of your service users gets injured, you can just say, but we've got desirable activities, so we can't be sued. It does mean you still have to risk assess, you still have to take concrete steps, but you don't have to go overboard. Having said this though, we still don't know how courts will actually apply the Act. It does allow for a little bit of leeway, so it's at the court's discretion to take this into account. There's a phrase in the second line, may, is quite important. So courts have a decision to make as to whether or not they feel this is relevant and should be implemented. There's no clarity yet as to what a desirable activity actually is either. I think we can safely assume that most voluntary activities, sports activities and so on would fall into this, but it hasn't been tested within court yet.